No second chances. Immigration can deny your case without any notice. New rule. So here we are again with the changes in immigration. I am your immigration attorney, Sekou Clark. So a memo was released earlier this year, and it's been more than a memo because there is actual action as to this particular change as it relates to immigration applications and petitions. So in previous years, I mean, as early as 2024 and previous administration, if you sent in a family-based petition for your father or for your spouse, and there is an error, a box wasn't ticked, or you forgot to do the proper filing fee, they will send you a request for evidence, or they would reject the case, and you have the opportunity to file it, to refile it. But guess what? Now in 2025, simple mistakes will lead to a denial right away. And guess what? If that person who is seeking that immigration benefit, once they are denied and they are out of status, they will be sent a notice to appear before an immigration judge. Yup. So there is a significant reduction in request for evidence or notice of intent to deny. That is what would put you on notice that something wasn't filed properly, right? But however, no, most of the cases, there isn't much notice, and they deny that case, not giving you the opportunity to correct your immigration filing. And guess what? Again, I'll say it again. If you are out of status, if you are undocumented, and that denial will now trigger a notice to appear before an immigration judge, aka you are now in removal proceedings. I've seen it, especially within my firm. I've seen people get their case denied. They come to me with their case denied on May 1st. By May 20th, they have gotten a notice to appear because they are now in removal proceedings. I've also now seen that if you submitted, say for instance, a marriage-based petition, and you do not have the right amount of evidence, the USCIS officer, based on this new memo, can now make his own determination right there and then, without an interview, without a request for evidence, that this case will not be approved or this case is potentially fraudulent, and it's denied, and you're now sent to removal proceedings. So this is where immigration is right now. So what does it require of you, right? It actually requires you to actually prepare before filing anything before immigration. I always say, go to USCIS, look at the website, look at the requirements for each filing, right? There's no AI, and walk yourself through those forms. But the forms is only half of it. There's the actual evidence that aligns with your case. Whether it's an N400 naturalization, N600 certificate of naturalization, or it's an adjustment of status, you have to have the right evidence, right? It blows my mind that people allow their files to be submitted, right? For instance, like an I-130, and there is no evidence. They send the bare bones. Those days are done. You have to be prepared. You have to know exactly what you're doing. And if you are not that person, just hire an attorney, right? Because now the stakes are significantly higher. It's not like you can just refile anymore, right? Your case will get denied and you will now be put into removal proceedings. And guess what? To defend your case in removal proceedings, it takes a significantly longer time and it's more costly. So do it right the first time.